Yes, good evening to everybody. Welcome to the moot court class. And this is a voluntary class. Those who are interested will definitely listen to me. At least one person also get benefited by lecture. I think that my mission is fulfilled. Yes, now you can unmute and read what I put on the screen. Of course, this is good evening because this slide I made for the good morning. Now you treat the good morning as a good evening. Yes, please read.
Good evening, sir.
Yes, please read. Good evening.
If everyone is moving forward together, then success takes care of itself. Henry Ford, Professor Dr. Mohammed Saheb Hussain.
Yes, gentlemen, you read it. Because morning I told you, Professor Hussain students, how they read.
If everyone is moving forward together, then success takes care of itself. Henry Ford, Professor Dr. Mohammed Saheb Hussain.
Did I read in the morning in that way? Yes, I will tell you that, how you should be written. I quote, if everyone is moving forward together, then success takes care of it. I unquote, Henry Ford. This is the style of reading the quotation when you are delivering the lecture, when you are delivering when you are discussing, or when you are presenting any paper in any national or international conference. Yes, that is the style of writing that I would like to share with you. Then next comes to our point is concerned, its moot is concerned, and I told you that I already gave yesterday the refined version of the moot code, the moot proposition 3, and there I mentioned submit the memorials on behalf of both the parties. And then I have given the statement of point that the issues also, there only one issue is exactly there, that is that whether the specific relief act would be applied by the party or not. That is only the question, and we have to revolve around that section 16 and subsection 3 of the specific relief act of 1963. And practically that now I'm showing you how you have to write it. See, yesterday we dealt this one. I believe that there is no doubt in the cover page. What are the content should be there in the cover page? Any doubt? You can ask me.
No, sir. No, sir.
Because everything that I made it in front of you, I prepared it. Yesterday I failed to fill this gap, but today I succeeded to fill the gap. And for you, need not worry about that one. You take the blue color page and you xerox on it. Then you can bind it and give it in the examination. Because I am not only giving you the way that you have to write it, I am teaching you computer savvy. I mean computer application also, how to use it and how to make it out. So this is the second page is a table of contents, which is consisting of the cover page, definitely page number 1, small Roman will come, and table of contents definitely it comes 2, because the sequence would be there, and there is the art of writing the small Rome number 1, then breaking it again, writing the Arabic numerals in consecutiveness or in continuity papers. That is also art, unless you know how to break the page and change the numbering. So that is also a computer savvy would be there, because generally whenever you are writing the book and the preliminary pages always in the small Roman, and the main pages in the sense chapter 1 to chapter 5 or 6, 7, whatever the chapter that you kept in your book, that would be the Arabic numerals. So that is the total thing. And come to the table of contents. Yes, now we are writing the same thing, and abbreviations and acronyms you can make it only when you write the full memorial. At that time, by going through the word line by line, we can find out what are the abbreviations and acronyms used in the entire work, that is memorial. And index of the authorities, whatever the cases that you cited, either the Indian cases or the foreign cases, and whatever the section that you used over there. But go in the sequence. First you write the sections, next you write the acts used, next you write the Indian authority, next you can write the foreign authority. Or if you don't want to make it like that, suppose if you are used the books in the memorials, the books also should come over there. But anyway, there should be some way, a logical sequence should be put it over there when you are writing, and that should be in alphabetical order. So here, because it is not, we are making that that much moot court competition memorial we are writing, and we are writing only memorial to get through the Kakatiya University examination. So the memorial here, what you write it, the section that you used over there, plus the authorities, the cases that you used, and the application, I mean the arguments to support your issues, and that will be in alphabetical order. Sir, there is only one issue, no sir, and you have cited the 6 cases, and you read the 6 cases total. No, that is your choice, because in the exam, of course, it is a home tech examination, so you have to only submit it, but preferably you cannot make it 100 to 200 pages only one problem question. Say about the 15 to 20 pages, if it comes, it's well and good. Total, everything should be covered over there. That is one memorial. Because if you write the 6 to 7 pages also, it's okay, because you have to cover memorial the both the sides. I don't know. I don't know what your examiner will say in that way, but I am teaching you for the both the sides how to write the memorial. Because when you are a doctor, you are studying the doctor. In the examination, there is no choice. Every question we have given, you have to attempt it. Suppose tomorrow a patient will come and say that, sir, I have the nose problem. Then you cannot say to him that, sir, I left it in the choice, that nose problem, in the question which is asked over there. So that would be not there. The compulsory that you have to read the everything, that you have to make it out. That is an example which I quoted here. So index of the authorities that already I have shown you in the earlier, how it can be made it, the cases in alphabetical order, you have to maintain it. Then the statement of jurisdiction, yes, this we can prepare it now. See, the statement of the proposition, when you want to write it, see, always make a fresh page, these all side headings which I made over you now. So now let us see the statement of jurisdiction. Jurisdiction. Yes. So now we have to see, and now you tell me this is what font? Anyone? I think that you could see my entire screen. Yes, you can see my entire screen, because I can see from here also. You can see the entire screen. So now, can you tell me the statement of jurisdiction is what font I used? Yes, unmute and give me the answer.
Times Roman, sir.
Times New Roman, that is already there shown in the bracket. And what is the point? Means size of the character. See, that is also shown in the screen. Opposite to the very right to the
14,
Times New Roman.
14.
It is 14. See, now I will just for a practical purpose, I will change it. Now you tell me what is the font I used it, and what is the point I used it. You tell me now. You look at the screen, you can read from the screen.
So Calter.
Calibri.
Calibri.
Of course, is the body. That is the body, the Calibri. And point
16,
means
sir.
16.
16.
So whenever you are writing in the examination, of course, in the examination you cannot write the font, all other things, because you are writing with the pen. But generally, if you want to use the common things, you can use the computer based. But only the argument, but you are supposed to write in the handwriting. Other things you can, if you want, you can make it out. Of course, that depends upon your examiner how you say. But in the moot court competition, everything will be computer based. So naturally, that when you are writing, because for your understanding, for your clarity, I am using the 14 generally. I am using the 14. It is a point, then times New Roman. This is the which I am writing, and this is a side heading. The side heading. What is the rule for the side heading? Rule for the side heading.
Left hand side, sir. It should be placed to left hand side.
Agreed. Next. Every word first letter should be capital letter, and except conjunctions, prepositions, and articles. And here off is conjunction or preposition or article. OF off.
Preposition, sir.
It is a preposition. It is a general proposition, not phrase proposition, nor compound phrase proposition. So that is the reason the O is not capital letter in off, and jurisdiction J capital letter. So side heading always the first letter of the first word is the capital letter, except the conjunctions, prepositions and articles, and should not end with any punctuation, and no underline, small letters, other letters are, and bold. So this is bold. How could you know that is a bold? Tell me. Because if you see the screen, the B is in yellow color. Did you observe? Here, cursor. See, from
Yes, sir.
statement
Yes,
of
sir.
jurisdiction, I am taking the cursor to B. See how the B,
we are looking, sir, yellow color, sir.
yellow color, but the bold.
Yes, sir. Bold letters
Yellow
are
color.
there.
Suppose if you change it, if I change it, no, the yellow color has gone. The yellow color in the B is gone. Means it is not bold. It is not bold. Now I am making the bold. So that's why it is the yellow color came to the bold, because the cursor is adjacent to it. So this is the statement of jurisdiction. So now you tell me, what is the statement of jurisdiction in the present case law? I already wrote in the cover page. Honorable Supreme Court of India at New Delhi is having a jurisdiction to entertain this case from the lower court by the virtue of, see, we wrote in the cover page. We wrote in the cover page.
Section 1 not,
Section.
We wrote in the cover page. At least look and look and tell me. Read and tell me. By virtue of section 100.
Section 5 of Civil Procedure Code 1908, sir.
That is the thing, the same. So instead of writing all the other things, what I do, I will select it, then I will copy it, then I paste it here. Instead of writing it, then I wrote the other thing which I just now told. See, this is the thing. So what you have to write? In the present case, Supreme Court of India, you can write your own words, no matter. There is no order. Supreme Court of India having the jurisdiction to entertain the case, the appeal, this appeal, yes, this appeal by virtue of section 100 subsection 5 of the Civil Procedure Code 1908. Here, if it is total side heading, means it is a paragraph end with the full stop. Yes, yesterday or day before yesterday, you know, no. What is the synonym for the full stop?
Dot, sir. Dot.
You can say dot, decimal point, period, point.
Generally, you are using dot, sir.
Generally, we can say that full stop or dot, we can use it. So that is a style of, it depends upon the country to country. In other countries, they will say decimal. But you should not say decimal, actual decimal point you should say. Because decimal comes only at that instant 13.56. And the 56 after decimal, there we write 13.56, that we read it at the time. So now, in the present case, the Supreme Court of India is having the jurisdiction to entertain this appeal by virtue of section 100 and the subsection 5 of the Civil Procedure Code. Is enough over. Hence, we can just to make it. Hence, the petitioner, no, that is a plaintiff, because we are arguing on behalf of, now writing the memorial on behalf of the plaintiff, appellant,
Or appellant.
not argual, not R, that is. R means anyone, either this one or that one. But both are the same. Hence, plaintiff Virgule appellant. Then that's enough. Here we can put the comma here, and we can make it a small h here. Hence the plaintiff defendant. The plaintiff defendant, yes, filed this case in the above court. Enough. So this is no. You can write it. Why I am writing all those things instead of writing only one line? Better to write 3 or 4 lines so it looks good. Are you following me?
Yes, sir. Something is they thought like that.
Yes. See how it looks only under the section so and so. If you write jurisdiction, it is not looks nice. You add some masala there, front and back, and see that it should be at least 4 to 5 lines. It should appear. So this is a statement of jurisdiction. Over. So now page nation, when you are making consecutive numbers, small Roman, that you can make it here, so that there is a matter. So this is the statement of. Then what is the another component? I told you there are 8 components. What are they 8 components? Can anybody will tell me now? There are 8 components I told you. Either you write the any memorial. Yes, anyone? See, I have shown you, I have given you, but still you are not in a position to give me the answer. See, these are 8 components. Cover page, we did it. Table of content, yes, we are making index of authorities only after making everything that we have to write it. Statement of jurisdiction, just now we finished. What is the next?
Fifth one, statement of facts, sir.
That is the thing. It should be by heart. It should be on your tip of your tongue. This 8 should be in the tip of your tongue. Either you write the memorial on behalf of the blue cover, or you write the memorial on behalf of the red cover. Is it clear? Say yes. Yes.
sir.
Now let us go to the point here. Yes, where you are. Okay. Yes. This is the case law, and we are here. More propositions. Yeah. So this is over. Okay. Next is statement of
Facts.
statement of fact. So there is another factometrics, but people will not write it because that is not that much famous. So better you write statement of facts. Actually, we should not say facts. We should say only fact, because fact is abstract noun. When abstract noun doesn't have s, can you say truths? Truths. We don't say. So generally, we are not suppose sometimes we should not write the abstract nouns in the capital in the plural form. Okay, the people are writing that you are writing because it became a habit of it became usage. So statement of facts. So of course they say the facts are many because this is one fact, that is second fact, this is a third fact. So that's why the people write the facts. Okay.
Excuse me,
Now,
sir.
yes, please.
Sir, in spite of truth, facts is a reason for related to court language.
Yeah. Because in fact, because they do use the court language, they use it such way. In court language, they change the up and down also in the English.
Truth
See,
is a universal, sir.
yeah.
Fact is the what happened we have presenting to the honorable.
Narrate and present it.
Yes,
So
sir.
yeah, so better. We will make it because I found a lot of mistakes in the judgment. I found it many places. Okay, let us go. Okay, let us make a point where statement of facts is there, and I already given the statement of facts. And statements are fact is nothing but the problem question which I have given is the statement of facts. The problem question which I have given to you is the statement of facts. So, the statement of facts, when you are writing in the memorial, you have to keep in one thing in the mind. What is that? The statement of facts always, yes, the same thing will come except the last sentence. I told you, both the sides only last sentence varies. Again, what I told? The facts should be, each paragraph should be numbered when you are writing in the memorial. I don't know why you are not catching that point. I have shown you model and I have given you everything, but still, shall I show the model because I have shown and we did the work also. We
Sir,
did the work.
really, sir,
Yeah.
really, we are not concentrate, sir.
I mean, that is an important factor. No, when you listen it, you have to concentrate, not to just to satisfy me that you have to present. You have to be present in my class. No.
No, sir. It is
Mm.
time factor, sir.
See, the last time that I have shown you, what is the difference between plaintiff writing and defendant writing, and appellant writing and respondent writing? What will be the changes should be there? I clearly mentioned, and I told you these are the things which are there. So when the facts are comes over there, when you are writing the memorial, at that time, see written memorials. This is the blue only, means the first part is side, and see the cover page, of course over. Then abbreviation, indexes, alphabetical order. This is also, and index to authority. This is also alphabetical order. Even section also, articles also, alphabetical order, and other legislation, alphabetical order. Then the foreign judgments or the Indian judgments, alphabetical order. And if the bibliography is there, then the bibliography should be written over there. And every statement, jurisdiction, yes, separate page that you have to make it out, what jurisdiction. And only the point is, when you are writing the jurisdiction, last point only varies over there. Because plaintiff may say the jurisdiction here, and here in the case law is, the appellant says, where their defendant will fully agree to this jurisdiction. In the defendant side when you are writing it. See, it is numbered. Did you observe it? In the second moot court, moot proposition, I put it this number. See, 1, 2, 3, 4, 5, 6, 7, and 8, 9, 10. Total 10. Only last line changes. Hence,
All
this
are
case,
Arabic numbers, sir.
the Arabic numeral should be there. And the last line we can say that hence this case was before the Supreme Court of India at New Delhi by the petitioner, that is the appellant, for disposal. Appellant for disposal. Actually, here we should write for disposal. That is appropriate. So this is the way that you have to write it. So in our present case law also we have to do the same thing, and that is yes, it is here. Yeah. Yeah. So this is the number 1, and here number 2. So number 2. Then this is number 3 paragraph, and this is number 4. And this is number 5. See, after making the arrestor, I did not put the full stop. Please note the point. See, it is very close, it is put over there. So better I can give some gap. Very closely it has come. So better, see when you make it, if the too much gap is there, then you can bring it. If the less gap is there, you can make it out. When the 4 comes over there, then you take the back, you can remove it. So this is the technique that you have to adapt it. See, and this is the way that you can make it out. Yes, more space is there, then you make it out. If not, then you can make. Of course, it is changed over there. When 2 removed, automatically it will come 2. So the first paragraph, second paragraph, third paragraph, fourth paragraph, 5 paragraph over. So this is statement of facts over. So see, it is end in the middle. So every time, don't start any side heading from the middle. Take the fresh. Yes, page. Why you are taking so much time to tell me? So what is the next component? I told you 8 components are there. What is the next?
Statement of issues, sir.
Yes, let me check whether it is there or not. Yes. Questions presented are the same, nothing but the statement of issues. So how many issues are there in the present problem?
8, sir.
I say facts are there, 8. Issues are there. I gave you the problem question. You did not read it, I believe. How many issues are there? This is the problem question. How many issues are there here?
Only one issue, sir.
Then why you are taking that much time? Because the class also I told you there is only one issue would be there. That is nothing but the whether the specific performance could be entertained or not. Answer is they could not be entertained. The reason that you know the better. Because the appellant is not readiness and make the thing to be the contract should be fulfilled over there, and hence they avoid the word they use. They avoid and make a plea that so and so, but they fail to make it out the readiness, prove the readiness and for the execution of the contract. Hence, specific requirements cannot be, he cannot ask it. So the same thing issues, because I'm relieving the burden, just I can copy it, then I can drag it, then I will put it over here. I need not to drag it because I copied means enough. So what should be written here? Side heading? Side heading, what should be the written side heading?
Statement of issues.
Statement of, what is the another way of, only one issue is there. Why do you say issues? What is another name for the side heading?
Statement of points, sir.
Very good. Appreciate. What is another name for the, again, the same set of issues, set of points? Statement. I wrote state. What is another name for the statement of issues and statement of facts? Sorry, statement of points.
Argument, sir. Argument.
No. Argument is the next component. I told you 3. See, here also it is given. I already made it. Statement of questions or questions presented. Statement of questions. Yes, only one question is there. Next component is
Arguments.
argument. Argument should I start from here?
Next page.
Fresh page. Next fresh page. Argument should be there. Okay. Now, when you make an argument, what do you do it? Practically, I will show you. See, this is argument. Argument. Okay, underline and make it bold. And write the first issue first. Already first issue we copied it there in the mouse it is. Then we can make it the first issue. Number 1. Okay. This is the issue. Now the question comes over there. Whether he can make it out the specific performance or not. That is the question. So if you read the case laws, then we can cite it. For instance, I will go through one case law to see whether it is applicable or not. Yes, this is Mukot. And let us go to this one. Yeah. See, one case law, Saheb Hussain-MP-III, let me take it. See, when you read the case law, you make a brief first. What happened in this case law? We need not to read the facts. What is the principle involved over there? That see, here is section 16 and class C clearly written, specifically Act 1963. That means this case law is very much relevant to us. So in this also, how to construe the plea of the readiness and willingness to perform to subserve to the requirement is concerned. So here the facts are given over there. The respondent defended by dismissing the suit of the plaintiff appellant for the specific performance of an agreement to sell. This resulted into the setting aside the concurrent finding of both the courts below the such degree to the appellant suit. For this, the sole ground was the appellant did not award this plaintiff that he is ready. So this is actually the gist. See, gist here you make it that. So in the case of, how do you write it? You write the case, of course, sir. The case name we need not to from here because already. What is the case law name is? Case law name is Saheb Hussain case law. So Hussain case law I already mentioned here. I can paste it, copy it then. Yet moot court. See, Dastagiri case law is here. So what I do? Where is Dastagiri case law? I did not mention Dastagiri case law here. Yeah, it is here. Say a Dastagiri case law. See? Okay. Then I copy it. Then I put it over there. But add the things a little bit change. So in the body, actually, the citation should be in the footnote. But we are not maintaining the footnote. So I write in this way. So that you could understand. In the case of, see, nothing should be italics. It is only the party name should be in italics and bold. Party name should be the italics and bold, but nothing should be the italics. So what happened here? See, I can go to the case law, then I will tell you. And which, yeah, this is the sad case law. And in this case law, I can go and tell it that what happened in this case law. Yes. There for this, the ground was apparent, never a plaintiff that was ready. Here I have read the case law. When the plaintiff approached, no, this is not. And award, here said, in this case, award the payment, when the plaintiff approached the defendant to receive the balance, no, this is not. See, just now I read it. For this, the sole ground was the appellant did not. See, here I can copy this thing. It is very much relevant to us. So, here we can go to the case law and we can write it. In the case of the so-and-so, and appellant did not ever in this plaint that he was ready and willingness to perform this part of the contract before adverting the issue, it is necessary to give some bare facts. So, he did not make it out. And with that reason, what will happen? Okay, he did not make it out. The appellant plaintiff filed a suit for a specific performance of the agreement to sale deed. According to the plea, defendant entered into the. We need not worry about all those things. What we are worried about is whether he is the principal involved in it is there. He's winning. He is winning the as he is taking the advantage of section 16 and class C or not. Let us see that High Court set aside the findings only on the ground that the plaintiff had not averred the pleadings strictly that he was ready and willing to perform his part of the contract, which is mandatory under the so-and-so of the aforesaid. No, High Court decision. So now let us go to the last point, what the Supreme Court has done. It was held in the case of Ramesh Chandra versus Chunni Lal. This is another case law. That the readiness and willingness cannot be treated as a straight jacket formula. These have to be determined from the entirely the facts and circumstances. Of course, this we cannot use it because he said readiness and straightness cannot be make a ready-made equation. It depends upon the case to case. We can say that whether the readiness is there or not. So now in this case, what you have to say is we also construe that such a plea, the plea of readiness, willingness required. Yes, according to the 16C, the readiness and the willingness should be required over there. And okay, in view of this aforesaid finding, we hold that the High Court committed an error. Yes, we can say that the Supreme Court held that. We hold that means who? We hold that means who? Yes, Supreme Court. Are you following me? Say yes. So,
Sir,
the SC, we can need not to write total. The SC means what? Supreme Court, and we hold no. The Supreme Court held that. See, we have to adding, making something should be there. Held that that the High Court committed an error of by defeating the claim of the plaintiff on the basis of the wrong interpretation of his plea in terms of the said section. So later on, what happened? Whether he succeeded or not succeeded, we will see it now. Okay. Accordingly, the impugned order of the High Court dated so and so is set aside and the plaintiff suit decreed by both the courts below is confirmed. But here, what happened? High Court decision is made wrong, they said. And with that reason, the plaintiff suit was decreed by both the courts below the confirmed, the appeal is accordingly allowed. But in our case, appeal is not allowed. Are you following me?
Sir.
Then what? How do you change it? How do you change the same thing now? Because by using that case law, we have to change our thing. Because there the appeal is allowed because they have proved it, readiness. But here, the appellant is not proved the readiness and willingness, hence his appeal is dismissed. That we have to write it now. Okay. So now it is made is out. But in the present case, in hand, the appellant failed to prove the willingness, which comes first, readiness and willingness. Readiness and willingness to what say? To execute the contract, to perform the contract. Because this is a specific performance. So when should we have to say? Performance of a contract. Hence, hence the appellant appeal was, what happened? The appellant appeal was
Dismissed, sir.
dismissed. Over. There they proved it. Same under section 16C. But here he did not prove it. And hence it's over. See, this is one case law that we can cite it. Oh, let us go to the another case law. We'll see that how far that is. Let us see Uma B case law. Yes, Uma Bai case law that we see. So Uma Bai case law, and this case law says what it says. Again, it also says the same 16C, if I have not been mistaken, because here is gone. 16C should be there. Then only it is applicable to us. Otherwise, we can we don't use it. Let us better check it whether 16 is there or not. Control F. Control F, if you make it out, then we can go to the find. Then 16C, see here it is there. What did they said? Totality circumstances, the land council would contend vis-a-vis the conduct of the parties would be relevant for the determining as to whether the plaintiff respondent has been able to satisfy the court as regards the fulfillment of the conditions laid down under section 16C of the Special Relief Act. That is, what is the section C of the Special Relief Act condition? That is the readiness and willingness. Okay, and here one point. Okay, next is section 16C of the Special Relief Act. What they said? It would appear that the plaintiff made a conditional offer which does not satisfy the requirement of the 16C. Means the plaintiff could not satisfy the section 16C. Hence, he could not force for the specific performance. And that is the only the gist. We can write it in the end by using it. Let us see how it is made. Where is 16C? Of course, he gave the different case law. But overall, for the reasons aforementioned, the impaired judgment cannot be sustained, which set aside accordingly, the appeal is allowed in the fact and circumstance of the case. Here the appeal is allowed. That means whether specific performance should be allowed or not, let me check it. The question came up before the consideration of the character of the custom Bombay versus Swastik Woolen. An appeal was being provided with this court to oversee that the subordinate tribunals acts within the law. No, this is not for our point. We should see the 16C. And yeah, this is not also part. Let us see better section C where it is there. Okay, now again we can make it control F, then see where it is comes, whether it is relevant or not. Our requirement is that, okay, that is one place they remain each statement having the regard to the entire returning. Okay, the section 7, they said, it is now well settled that the conduct of the parties with a view to arrive at the finding as to whether the plaintiff respondent were all along and still are already, not already, ready and a willingness to perform their part of the contract as they mandatorily required under section 16 subsection class C of the Special Relief Act must be determined having regard to the entire attending the circumstances. A bare averment in the plaint or a statement made in the examination in chief would not suffice. The conduct of the plaintiff respondent must be judged having regard to the entirety of the pleading, also the evidence brought on record. And here, my question is, we are arguing on behalf of the appellant. We are arguing on behalf of the appellant. Is it?
Yes,
Yes,
sir.
sir.
When you are arguing on the behalf of the appellant, you try to protect him or you try to defend, you try to kill him.
Protect
Yes.
him, sir.
When you
Protect
protect him, how we wrote this thing, it's wrong way of writing. See, when you are protecting the appellant here, can you say the appeal is dismissed?
No, sir.
You should not supposed to use this case law at all. Are you following me?
Yes, sir.
So what you have to use it? Now I read case law is a bit relevant because he said awareness and readiness cannot be judged by the facts of the case law. There is no tight jacket would be there, and he cannot just make a blame on that he is not doesn't have the readiness. And in that respect, section 16C conditions my appellant has fulfilled. Hence, the judgment should be in the favor of the appellant.
It is
Means
true, sir.
we have to protect the appellant. Appellant says
Anyway,
that yes,
in any way, we have to protect the appellant, sir.
even though that because that is the art, that is the counsel. What I say, counsel tactics, and that is the advocacy. See, advocacy is, I told you, no, a lawyer only can make white to black and black to white. Like a painter can make black to white and white to black.
Just changing dress.
Yes, he will make white to black, he will prove it. And again, on behalf of the opposite party, he say, no, it is not a black, it is a white. That means black to white he will make it. That is the argument and tactics and the efficacy and the strongness and the
Advocacy. It means
yes,
called
yes,
advocacy.
that is either in the pen power plus in the oratory, means oral power.
Yeah.
And you have to make an argument. When you are making an argument, every time can you look at the book and make the argument? Every time you see the section, I beg your pardon, my lord, and again see the section and make a so thing. No, you can write in a small paper in front of you, you can put that hand and you can just bend down your eyes and look at the figure or look at the case and look at the thing. Then you can make an argument without any pause. If you make an argument, the argument is 30 to 40 minutes. And sometimes it goes to 1 hour also. In that way, they will make an argument. So still the 5 minutes are left over there. So now, what we have to do is see, when you are supporting the issues, first you have to check whether it is relevant to us or not, whether we are defending there or not. The case law which we referred is not defending it, it is offending it. So better we should not use the case law. But ambi case law is somewhat, it is having a life. This is ambi case law, it is having some life where it can say that yes, it can be used over there because there is no hard and fast rule to make it prove that it can be made, and that is the reason he is in a position to perform, and he can the ingredients of the section 16 subsection class C, that is willingness and readiness to perform the contract. So that way that we have to write it. So this case law we can use it to support, and you can take one more case law also, you can support. Enough, 2 cases are enough to support your argument. To say that what? Tell me. Appeal would be allowed. You have to say all the time. The reason is we are protecting the appellant. So we shall see that he is readiness to make it out. But we know that overall judgment is there. We know it. We know it because it is already a decided case now. So in a decided case, we know the result. So when you know the result, definitely, but that is not the important. Protecting the important. But when you go for the yes.
Sir, in this regard, we may be taking for reference
Yes.
decided cases, but
Yes.
what is our intention is to allow the case at any way.
That is our intention. In any case that we will say that let my counsel, let my client here, whatever the either is a appellant or plaintiff, whatever it may be that you are arguing on behalf of him. Here is the first party. The first party in the sense of plaintiff and appellant. You try to see that he will be favored, and in his favor the judgment should be given. That way that you have to convince to the judge. So it is depending upon your convinced power, then either you lose the case or win the case depending upon your capability and caliber.
Of only advocate only depend on.
And advocacy and your language. And you try to convince him in the way that he should not say no. He should not say no in that way that you have to convince him.
Pretending capability, sir, depend on.
Yes, definitely. It goes on the capability of advocate also. Because if an advocate on the same facts which a person has lost it and he can get a win over that same facts. But only presentation is different. See that you posted the posting yesterday. If you have a dareness, then నీ పాదాల దగ్గర ఏముంటది
విజయం
ఈ ఓటమి నీ పాదాల దగ్గర ఉంటుంది. ఇఫ్ యు మేక్ ఇట్ ఏ హార్డ్ వర్క్, ఓటమి నీ ముందట ఉంటది. అంటే అర్థం తెలుసు కదా మీకు ఏంటిది ఇక్కడ ఇంటర్ప్రిటేషన్ లో నీ పాదాల దగ్గర ఉంటది అంటే అర్థం దట్ యువర్ డిటర్మినేషన్ విల్ మేక్ ద ఫెయిల్యూర్ ఎట్ యువర్ ఫీట్ ఆర్ అండర్ ద ఫీట్. అంటే
overcome the failure.
Overcome the failure and the success in front of you, and means you can obtain the success, you can enjoy the success which is in front of you. So it is your hard work, definitely it will count it. If not today, tomorrow that you are going to reap it. See the hard work which I am doing now, definitely I will reap it in future, because I know if I may work hard, then I will enjoy the fruits in tomorrow. That is the one thing. Because by giving the explanation to you, even myself also read it, then I will be enlightened. I will be enlightened with that one. And that gives a sense to me. Even I did not know what is bank, bunk and bank. These are the 5. I don't know how many people, of course, in the morning the area